For years, Labor Day was the traditional start of the push to the fall ballot. Of course, that's all been thrown out the window with the new way of campaigning, essentially starting a run for office on the dawn of the day after Election Day. This is a so-called off year, and while we do have 3 ballot issues, there are no marquee statewide candidate contests, such as governor, U.S. senator, or president. But in 29 counties, there are judicial races, and some counties are filling multiple seats on the bench. However, there's usually little information about the candidates in these races. That's where a new website called judicialvotescount.org comes in. It is a partnership of the Ohio State Bar Association, the League of Women Voters of Ohio, the Ohio Newspaper Association, and the Ohio Association of Broadcasters. It's housed at the University of Akron's Bliss Institute for Applied Politics. The website is part of a 3-point plan to reform judicial elections in Ohio that was created by Ohio Supreme Court Chief Justice Maureen O'Connor. And I'm pleased to welcome Chief Justice O'Connor here to talk about that. So this 3-point plan, you've got the website, Judicial Votes Count. Why is that so important to be part of this plan, and what are the other elements of the plan?
Well, the website is a result of a survey that was taken, and the number one response, the majority of the folks that said we don't vote for judges, and the response of why is because we don't know. We don't know enough about judges. We don't know who they are. We don't know what level of judgeship they're running for. The confusion on what judges actually do and our multiple levels of judgeship it really came through in the survey. And it didn't tell me anything I didn't already know. I mean, everybody knows that, and you just look at the voter drop-off. And you look at they call it a roll-off.
You've called it ballot fatigue, as other people have.
Ballot fatigue is another word for it. In the counties where there is an extensively long ballot, they call it ballot fatigue. But, it probably about 25%, as high as 40%. In 2012 in Cuyahoga County, on that ballot, there was Supreme Court, Appellate Court, and Common Pleas Court judges up for election, and there was about a 40% voter drop-off in the voters that went to the polls. So we knew that the problem was real, that people don't vote for judges. We also know that there's a reason for that, and it's because they say, I don't know enough about judges, I don't know enough about the candidates. So the solution, a pretty simple solution, is let's set up a central repository for all of the information about the candidates. Let's have uniform information about each candidate, whether the office holder, current office holder, or the challenger, and people can do one-stop shopping. They can look at the people that are running for office. They can compare the answers that they give to the identical questions, and those websites can be supplemented by additional information as the candidate provides for the Bliss Institute to incorporate, such as an endorsement they may have received or something significant that happened during the campaign that would be influential on their electability. And that's basically what it's all about. You know, people use social media, they use the website. You know, I joke that people spend more time figuring out what pair of shoes to buy online than they do at familiarizing themselves with the candidates for political office. This will make it easy. And we've had it up and running in about a week, I'd say about a week, maybe a little less. And we've already had about almost 5,000 hits. So that's pretty good.
Now, before we talk about the other points of the plan here, I want to ask you, there are several candidates on the website that are marked as declined to participate. Why would that be that they would decline to participate?
Because they don't have an opponent.
Well, that's another one.
Yeah. We do have a number of judgeships in this state when the incumbent is up for reelection, they don't have opposition. I'm not saying that every judgeship should have opposition. That's not my goal here whatsoever. And so the ones that did not participate, I think, are the ones that do not have opposition. Now, I was at the judicial conference last week, and I said to the judges that were there, just because you don't have opposition, please fill out the questionnaire. Please submit the answers to these questions so that the public can get to know who you are. That's part of, I think, a service, an educational component. Because not only do we talk about the judges and the candidates and their information, but there's a information part, the beginning of it, that tells you about the different judgeships that we have in Ohio, what judges do. It's a video, a very short video for each one of the judgeships, and the speakers are former judges, and they talk about what they did as a particular judge, whether it's a juvenile judge, a probate judge, common pleas, appellate, and Supreme Court. And municipal. So it's an educational tool, and people are curious about your local office holders. And I think even if you don't have opposition, it's incumbent upon you to do that. I spoke to the Judicial Conference audience, and lo and behold, since I asked them to do so, some of our judges that were unopposed saw fit to respond and put their information there. So I'm glad.
I want to ask you about the whole idea of ballot fatigue here. And you mentioned the drop-off. In 2012, we had a governor's race that got 3 million votes. And some people thought it was a lackluster governor's race. But still, there was a drop-off even from that down to 2.5 million in the Supreme Court races. Are people not voting, like you said, because they don't know enough about candidates? Or is it possible there are just too many candidates in these big elections where you've got, president or U.S. senator or governor? Do people get tired by the end of the ballot?
I think that they do. I think they do. And I think one of the solutions that I've thought of was to move these elections for judges to odd years. Right now,
the second point of your plan.
Yeah, now they're in even years, except for municipal courts. Now municipal court is in the odd year. Let's move all of our judge races, our elections, to the odd year. Let's relabel them the judicial years, and we will get a bigger concentration of attention on the judicial races if we're able to do this. You're right, the competition, if it is a presidential year, and I've run in a presidential year, if it's a gubernatorial year, same thing. The airwaves are inundated with all sorts of commercials. I joke in 2010 when I ran for Chief Justice, I put, I think, about $500,000 on television, which is a tremendous amount of money, not compared to what other candidates put on, but for a Supreme Court race, that was a good amount of money. My commercials were so infrequent, I didn't even see one. So we need to, cut through that, and we need to give a forum for judges to get their message, who they are, what they do, what their record is, get it before the public. Let's do it in a less crowded field, and that's why it will take a constitutional amendment to do this, but we can move those elections to the odd years. People can then concentrate on judicial elections and make a very informed choice when it comes to that.
The other point of your three-point plan would be increasing the qualifications to be a judge. Do you worry that that might have a detrimental effect on the number of people who want to run for judge? Because you even mentioned that in many of these races, these judges are running unopposed.
Well, they are running unopposed, but I don't think it's because they have, attorneys that are 6 years or under in practice, but for that pesky 6-year rule, they'd be running. I don't think that's the issue at all. We're talking about enhancing the public confidence in our judiciary. Teach the public about what the judges do, teach them about who the judges are, and let's see if we can change the culture and enhance the awareness of the public. And part of that is in upgrading the qualifications for the judiciary. Right now, it takes 6 years as a practicing attorney, and you too can be Chief Justice. And I don't think anybody thinks that that's near enough time in order to do this job. So, or you could be an appellate judge or common pleas court. And I just think that the qualifications should be increased, and that would be up to the legislature on how they would do it. The number of years, it's been suggested 10 years for common pleas, 12 years for the appellate bench, and 15 years for the Supreme Court. That's not unreasonable. But I would like to see them increased.
Now, one of the other reasons that's been brought up sometimes in the discussion of why don't more people run is that the pay is not what maybe it is in the private sector. The legislature did increase pay for judges, but it's a 2-year budget, so there's 2 pay raises there. The final 2 years, There's no guarantee, right?
Well, there is no guarantee, but they put the legislation in for 4 years, and what it will take is another budget cycle to fund the last 2 years of those pay increases. And I have to say that the leadership of the House and the Senate, Senator Faber and Speaker Rosenberger, as well as the governor, it was so appreciated by the judiciary. We worked with them for the 6 months on the budget. I put it in my budget, and those gentlemen saw fit to pass that in the budget and also sign it into legislation, and we are, as a whole, very grateful to them.
I want to ask you, too, about criminal justice reform. Big topic this week with a commission that's going to look at sentencing guidelines and that sort of thing. What do you think from the judicial side of things is really important when you talk about trying to lower the numbers of people in prison but still keep the population safe?
Well, accountability is the key there. There is the the commission that's put together to take a look at the recodification, and that's an important factor. Whatever is done in order to shift a certain level of population of defendants, instead of sending them to the state prisons, the state institutions, if they are going to be kept locally, the key there is funding for the locals to be able to manage those populations in their local communities with, the probation and the treatment and the monitoring and the accountability. And that encompasses a broad range of agencies and entities that have to be involved. You're going to have your social service. You're going to have your, psychiatric and mental health facilities. You're going to have drug and alcohol treatment, and you're going to have your courts and the probation system all adequately funded. So it's great to take those defendants and treat them in the community and relieve the cost and the burden on the state system, but you can't shift the burden to the locals without shifting dollars there as well.
And what about judicial discretion, where judges don't have to follow mandatory minimum sentencing guidelines? They'd have more discretion to go case by case. Is that a good idea?
Well, you always hear trial judges saying, yes, that they want to have that discretion. Although there's a camp of the trial judges say, no, it's okay the way it is. But I think whatever they come up with in the recodification will, because there's judges on that committee, that's what's important, is that it is made up not only of law enforcement and legislators and other interest groups, but there are a number of judges that are part of that recodification program. So they're going to be addressing those issues head on.
Thank you very much, Chief Justice Maureen O'Connor.
You're welcome.
And that is it for this week. For my colleagues at Ohio Public Radio and Television, thanks for watching.